Allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that approximation as per now is that 21 days will do justice not just to us, but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1)G and Article 49(1)H. I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1)G, which requires at first appearance that he be charged or informed of the reason for his detention or to be released, once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed, in my view, in my very respectful view, is that the threshold is met once the reason is given and it is satisfactory to the court. The arguments about compelling reasons, arguable reasons, are reasons which are better still placed on arguments of bond pending trial. Let me hit the last point, which is apprehension vis-a-vis likelihood. I have heard Mr. Ompeta, who I respect so much because the decision in Dwight Sagerai is one of my best read decisions in this country, tell this court to ignore the bail and bond policy guidelines. Although he said it in passing, but that was very unfortunate in my view. Because the bail and bond policy guidelines is intended to standardize the application of the law on bail and bond in Kenya. And if I get it right, I think it is clause 4.9 of the bail and bond policy guidelines. The word likelihood is used at least 3 times. So that the likelihood to interfere with investigations is a sufficient ground, even if you are arguing bail pending trial, to deny bail. But on this lower threshold of a balance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I humbly pray. Thank you very much.